Good morning, everyone. Here, will you call the roll, please?
Representative Bratton.
Here.
Representative Jessic.
Here.
Representative Feiler.
Here. Here.
Representative Lee.
Excused. Here. Here. Thank you. So we're off and running. First meeting of the 68th Legislature, House Judiciary. Just a couple of things before we get going. Just a reminder to the committee to make sure you use your microphones, especially when voting. And we have an audience out there on YouTube, and if you don't use your microphone, they often can't hear us. About 6 inches works pretty good with your microphone, and everybody can hear you. And that way, everyone knows what we're talking about here in the room. Just in terms of our decorum, the legislative process often deals, especially in judiciary, with some contentious issues upon which not everyone agrees. So it's absolutely critical that we maintain decorum in the room, that we accept all points of view. Everyone gets a chance to voice their opinion, and they come to the microphone, they're recognized by the chair. One of the most important aspects of that is that all communications come from the witness at the table to the chair, rather than to an individual member of the committee or to somebody else in the room. So direct all your comments. You'll have some very experienced testifiers up here to start, and so everybody get a good example of how that's done. The other thing I want to emphasize is that in the citizen legislature, there are always trade-offs, right? And the biggest trade-off in a citizen legislature is that we have very short sessions. We only have 37 days scheduled for the 68th general session. That means we have to be efficient with our time, both as committee members and how we phrase our questions and the statements that we make, and witnesses from both the state agencies, legislators, and members of the public who are testifying. So stay on point, tell us what we need to know. Don't feel like you have to rush and leave things out, but be conscious of the fact that we have 2 hours this morning to get through 2 bills. All right. So there are copies of the decorum rules if you're not familiar with them out front. Most importantly, just be polite and kind to each other, and it works pretty well. Simple as that, little golden rule. Okay. So our first bill this morning is House Bill 48. House Bill 48. It comes to the Judiciary Committee from the Mental Health and Vulnerable Adults Task Force. For the new members on the committee, task forces do not have the authority to bring legislation on their own. So they do work. They have oftentimes have members outside of the legislature who are part of the task force. They then come up with ideas for possible legislation, and then they bring it to a committee and ask that standing committee to bring that bill forward. And that's what happened here. The Mental Health and Vulnerable Adults Task Force worked up a couple of bills. They brought them to Joint Judiciary during the interim. Joint Judiciary agreed to, I don't know if adopt is the right word, but close enough. You get the idea. We embrace them and we sponsor those bills. And so that's what brings this couple of bills to us this morning. So with us as chairman of the committee, Representative Larson. Why don't you tell us what we need to know about House Bill 48?
Thank you, Mr. Chairman. And for you new members here, this is my 13th year of presenting before committees, and I still have to be reminded to go through the chairman. So if you fail in doing that once in a while, don't panic and feel like you're going to be sent to a corner. We get passionate, and that's why we have good chairman like Chairman Washut to help us maintain that decorum. Mr. Chairman, if I may, because both of these bills come out of the Mental Health Task Force, I'd just help educate the new members into the legislature to understand this task force was created 2 years ago, and it was preceded at that time by a substance abuse subcommittee for the intent to consider and recommend policy to determine the state's role in providing mental health services to the citizens of the state, so that we didn't get the cart in front of the horse or inefficiently adopt programs or policy. So, and that was important so that when we consider programs, we have policy in place to govern it. The task force was made up of House members, 3 Senate members. Then we had representatives from the Department of Health, the Department of Corrections, Department of Family Services, Department of Education, and the Supreme Court. It was really a unique task force having that level of executive branch people here, but all of those agencies deal with mental health issues and they overlap. And so having their input has been very helpful. But because we had legislators and executive branch people on this task force, hence the reason why we couldn't sponsor any legislation. Executive branch can't do that. So then over the last couple of years, I think we've sponsored 6 or 8 bills that have come, and I think probably 60% of them have then been sponsored through this committee. So that's a little bit of the background for these 2 bills. The first bill before you comes, and I'll turn the majority of the discussion or the explanation of the bill to Director Corin Schmidt, who's the director for the Department of Family Services. But as we talked about these various agencies and dealing with mental health, then there has to be the ability for the agencies to communicate. And over the years that I've been in the legislature, there's been a couple of really significant issues addressed. One is we had systems within agencies that couldn't talk to each other. We've upgraded those technologies immensely, but now we have to give them the permission to communicate the information that we need to have. And so as the Department of Family Services gathers information that has a lot of privacy concerns, which are very, very important to us, how do we share that information and protect the privacy of those that are involved, and but yet at the same time not miss opportunities to prevent unfortunate situations from taking place. So the intent of this bill is to navigate or thread that needle and allow the agencies to talk and to share information, at the same time protecting the privacies that we are required to have through HIPAA and other statutory, both federal and state requirements, and get the job done. So, Mr. Chairman, with your permission, I'd like to have Director Schmidt go through the bill, explain the bill. And Mr. Chairman, as I explained to you earlier, Anna Johnson, who was the task force attorney, is here. And if we have questions on the drafting, she's available for that as well.
Director, welcome.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the director of the Wyoming Department of Family Services. Welcome to the legislature. Welcome to this committee. I look very much forward to presenting for you. As a side, I am available to you at any time if you have any questions. Our agency is large, but 80% of the work is happening in your communities. So if you ever have any questions about what we do, how we do it, please contact me, but there's always somebody locally for you to speak with as well. So to highlight the chairman's points about privacy and confidentiality, our agency, as you can imagine, in a world where we're serving children, families, and adults, collect an incredible amount of information. We take privacy very seriously. What we know is that many of these families, regardless of why they come to us, are usually in crisis. They usually have some level of deep need for the services we provide. We understand that, we respect that, and because of that, we take seriously the confidentiality of the information that we gather. However, the confidentiality statutes, in large part, that were created in the 70s, and they didn't contemplate a time where maybe we could help these families a little bit earlier, a little bit more effectively, while also being good stewards of the dollar, while also ensure efficiencies across our systems, both internally and externally. So as we have continued to build out technology, and as we've learned more about the people we serve over time, what we've come to recognize, and through the work of the task force, is that there are some places where we have barriers to being able to serve families better and also to know more about how those families do over time. We have frequently been asked the question, how many kids that you serve in your juvenile justice system go into the Department of Correction system? We can't answer that question. And one of the reasons we can't answer that question is because of our confidentiality statutes. When they were written with a very singular intent in mind, and that was around that child, that family. The information that we can share around those families is usually very limited to people who are directly involved with that case, meaning law enforcement, a judge, attorneys, etc. So that case stays very close to the work. The information stays very close to the work. But at the same time, then, we really don't know or understand how our system works as a whole. The technology is something that is scary for all of us. I mean, we've had lots of conversations about what everyone knows, what people don't know. And one of the things that's really important for me to say and for you to hopefully support is this understanding of how we protect confidentiality. It comes with a lot of data governance. We have a protocol in place by which we share information if it's allowed. We have agreements, written agreements with other entities, Department of Health, the judicial system, so that everyone knows exactly what information we are sharing and how. We also are very supportive of anonymous data, de-identified data, and internally, we do a lot with de-identified data. But once we want to go from one system, even internally, even if we want to go from one system, IT system, that collects information on who we're serving in terms of benefit programs, like TANF or SNAP or weatherization or utility assistance, we cannot connect or know anything about if any of those families are also being served in our social services system, adult protective services, juvenile justice, child protection. So even internally, we don't have permissions to share that data to know and understand more about who we're serving so that at the end of the day, we can do a better job of providing those services. So what we are requesting in this legislation is really kind of three purposes for sharing data. And the mechanism by which we're asking to share data is through rules. So when we were working on this project through the task force and trying to come up with wording that would capture all the reasons that we may possibly want to share data, it became very difficult. So the approach that we took was to give the director, whoever the director it is, authority to give permission to share data around very specific issues and projects, initiatives. With that data then would come a rule promulgation process. And the rule promulgation process is a public process. So if there's any given opportunity, initiative, project, the director would then decide if that's appropriate, would decide what information could or could not be shared with whom, and then rules would be promulgated around that, which then go out for public comment. Also, part of the rule promulgation process is an opportunity for the legislature to review. So since we don't have any authority to really get out and speak with the general public in a formal way, we do it informally all the time, but to get formal comments then can come through the rule promulgation process. We can know and understand what concerns are. We can try to address those concerns, but then the general public also knows what it is that we are doing in a very transparent way. So the three general purposes of what we're asking, the authority that we're asking for the director, comes first around referrals. And because our system is so closed, we have a very difficult time sharing information with our service providers in our communities to be able to help them, help our families get the services we need. And a specific example of that is home visitation. Home visitation in general are programs that have great research supporting that they can impact the risk of abuse and neglect. That intervention, support services to young families, to early families with infants, with small children, shows that that kind of service has a greater chance of reducing risk for abuse and neglect later on. Our department purchases services, home visitation services, through a couple of ways. One is through the public health nurses in your communities. We provide funding to the Department of Health, who then supports local public health nurses to do home visitation. And then another way we provide home visitation is through a contract in our agency for a model called Parents as Teachers. So if we have a situation where a family comes to our attention, maybe a call from a school, it may be a call from a concerned neighbor, it may be a call from somebody in the church that says, this family is really struggling, can you go help them? Well, we have the authority to go talk to that family, but more times than not, the needs of that family aren't going to need the level of intervention that we offer, meaning that there isn't the level of abuse or neglect that says that the statute gives us authority to then step in. We can offer voluntary services, which we do. We can say, we know that this may be a little bit hard. Here's services that we can provide. We can work with you voluntarily. But at the end of the day, that family can choose to not work with us, and that's fine. But what would be helpful is if we could also call the public health nurse and say, we have a family, young infant, they may need a little bit of help. We've given them your information, we've given them your card, we've asked them to call you, but perhaps a follow-up call might be helpful. And the reason why that's important is because when DFS comes, it comes with some scary and some perceived scary intentions, right? We come with authority, we come with government, we come with all those things. Even though somebody may want to work, may want the services, but because it's us who's working with them, they may have a tendency to not. But if a public health nurse calls or somebody who's providing a different kind of service calls, that's not government, that's a support, and then they may be more willing to engage. This is especially important from what we know about fatality rates and major injury rates in our system. National data research is showing that the common thing around all those cases is missed opportunities at the very beginning. That lack of communication, lack of being able to connect those families very early on shows up in almost all of those cases. This is a different approach than the child welfare system has usually taken. This is very much a prevention approach. And we recognize that those services that are provided locally, that your community providers provide, are the best chance for those families to reduce their risk of any harm to their children. So first and foremost, that's what's most important to us. The second example is really around the provision of services. And that's the actual service that we provide, we track. And how are we doing with that? And are we connecting from agency to agency? What do those services look like at the Department of Health? What do those services look like in the Department of Family Services? Are we duplicating? Are we not providing enough? Are there gaps? And the example of that is with the behavioral health redesign project that has been going on for the last couple of years. And that's been an intentional redesign, a model of treatment or of the service delivery of treatment that the Department of Health, with which we support and partner, provide direct services to families that are identified in need from the Department of Family Services, corrections, and local communities. It is a new idea, it's a new concept, But right now, we cannot share any information about the families we refer to the Department of Health so that they can see on their side what they're getting billed for. So the Department of Health buys the services, we use the services, and we can't have the conversations through a data way to tell us how that's going. That's an important component for, one, just to make sure that we're not seeing duplicate billing. We're not seeing somebody getting a service 3 times through 3 different providers from the same purpose because we purchase some and the Department of Health purchase another. But also to see how this whole project is working, how this reform is working. It's a novel idea, but we have to be able to share information so that the Department of Health can determine if it's working. And then last is kind of goes
Director,
back.
let's pause just one moment. There's a limit of how much information we process without questions. So I just want to give the committee an opportunity. Does anyone have any questions thus far for the director?
Well, I do.
Representative Brady.
Thank you. When you just mentioned duplicate versus triplicate services, you want to avoid those? Is that correct?
Director?
Mr. Chairman, Representative Brady, we want to know if they happen and why they happen, and if there's anything that we need to address as a result. So the department buys services through our local caseworkers, and we track those through our case management system. The Department of Health purchases services, Medicaid primarily, and they track the purchase of those services through their system. We don't know if one person is getting a service that we're providing with State General Fund and also receiving a different service with Medicaid, or the same service but with Medicaid. So it's just a way for, one, fraud prevention, being able to analyze that data when necessary, and then also to understand what our clients need or what they're accessing.
Thank you.
Further questions? Representative Kelly.
Thank you, Mr. Chairman. First, just to clarify, what I'm wondering here, I'm looking at 2 different ways to share information. One, which is intuitive, that the state already has this information but cannot share among agencies. So we'd be looking to open up that avenue. But I'm also looking at the state possibly sharing confidential information with private providers. And that's in the context of a director who makes rules which are not specified here. So what assurances would we have that these voluntary contacts to private agencies wouldn't become mandates to private agencies to look in on families?
Director.
Mr. Chairman, Representative Kelly, in terms of the mandate, those are services that we're already purchasing from that entity that come with contractual mandates. So, for example, the public health nursing statutes require a contact with all new moms. So what we're looking to is to be able to help the public health nurses meet their current mandates, to be able to connect with those families that are most at risk. You can assume if a family comes to our attention, there's some level of concern there, and just doing a better job of referral. At the end of the day, those services are still voluntary. The family can choose to opt out. We're just asking for the ability to make the contact.
Chairman Larson.
Thank you, and Representative, thank you, Mr. Chairman, and Representative Kelly. The second component of that, which you alluded to, that I think is really important. So it may not be in the green books, right, the statutes we have in front of us, but the rulemaking process is really important to provide public input on the adoption of those rules to determine what type of information can be allowed. That is something that comes back to the legislature. It's something that every member of the public can participate in and voice in. And that's, as she noted earlier, when we thought about how we try to put all of the various possibilities in statute, we concluded that we couldn't. There's just a lot out there. But as they evolve and arise, The stop there is you can't automatically do it. There has to be rules to allow it, and the director has that authority, but there's a rulemaking process then that allows for public participation.
Further questions? Okay. Please continue, Director. We're coming up on 8:30. Just to remind everyone, we need to be on the floor at 9:45 for the State of the State address this morning, so we have a hard break.
Thank you, Mr. Chairman. And then I've already hit on the third, which is the research, and those are the outcomes. That's looking at how we serve our population across all systems and are our services working. And we really can't know that if we don't know if there's other connections to other parts of us. The one that is highlighted in this particular piece of legislation is the state longitudinal education data set. The permission to participate in that data set comes with this legislation, but we also need the ability around our confidentiality statutes to share. And that's really talking about educational outcomes for the children that we serve, the families we serve. And then as a result of education, are they going on and receiving accreditation or certification in the trades or continuing on to community colleges or other higher education? So the bill itself is long but simple. And the majority of what is important in this bill comes on page 2. In 9-2-2104, lines 1 through 12. And typically, Mr. Chairman, I know that the LSO may read the bill. I could either go through it or defer to the LSO.
Whichever you think is necessary to convey what you need to convey.
Mr. Chairman, I can do it. I think it's pretty simple. It looks big, but in fact, it's pretty easy. So this is where the page 2, lines 1 through 12, is where the permission or the authority is given to the director to make the decision about whether or not we should share some information around a particular initiative, project, purpose. And lines 11 and 12 really get at the heart of it. It's for referrals, it's for provision of services, and it's participation in bona fide research. And the term bona fide research is a common term that's used throughout a lot of legal work and academic work that just says it's legitimate, it has a basis in protocols, it has a basis in kind of a structure on how the research is conducted. So the majority of the bill is then looking at each individual confidentiality statute that would be affected by this particular authority. So we have confidentiality statutes around our child protective services work, our juvenile justice work, our adult protective services work, and our children in need of supervision. None of them are worded the same. So when we tried to go in and maybe modify each of those provisions, the bill became extremely long, extremely complicated, and the wording was difficult. So from just a strategy standpoint, made the decision to give that authority, which would have come in individual clauses anyway, but giving it in general, and then specifically citing that authority in the confidentiality statutes themselves. So really, it's a conforming. It takes the authority and says, in this place, this place, this place, and this place, this authority is allowed. So if we look at page 2, line 14, this is our child protection statutes. And you can read through lines 19 on page 2 through line 3 on page 3, and that is where we have very prohibitive language. It says that we really can't even talk about whether we got a report. So if somebody calls us and gives a report, after that, we will not say anything to anyone unless there is reason through the work to be able to make contact as allowed. So that's how restrictive it is, and for good reason. But and I have no interest in reporting back to everybody about what's happening. But that just tells you that once that case is made to us, we don't share it at all. Any of the information resulting from that case is not shared unless it's with specific people. The interpretation is that then you can't share anything with anyone regarding any of the other data. So if we want to make a connection on the provision of services, we shouldn't even be telling the Department of Health we're serving that family or had some sort of contact. On line 5, page 3, this is around our juvenile justice statutes when we serve juvenile delinquents. Line 17 on page 3 is for probation. So we provide, in most communities, community probation for juvenile delinquents if they're ordered into our probation program. Some of your communities have their local probation that also serve youth. We're talking about youth that are coming to us through this statute. Line 5 on page 4 is our children in need of supervision. That's another way that families engage with us if they have a child that needs a lot of support and the family is having a difficulty supporting that child. This is one of those petitions or legal ways that the department can come and become involved. So lines 5 through 10 are for our child in need of supervision. Also on page 4 is a reference to the Juvenile Justice Information System. And the Juvenile Justice Information System was a mandate from this committee to us in 2019, 2020, where the information system was given to the Department of Family Services from DCI, the Division of Criminal Investigation. And this committee asked us to start collecting that data. So we now collect that data, but we cannot connect it to anything else in our agency. So we have the information and we can tell you about statistics, certainly with that population, but nothing then that connects them to our juvenile probation that I just mentioned or the juvenile justice. So it's very contained. Then as you look to page 5, lines 16 through 22, this is in reference to the state longitudinal education data set. These statutes are the Wyoming Community College Commission statutes. This just allows them and allows us to participate in that effort. Line 6, or page 6, line 1, these are our Adult Protective Services statutes. These are vulnerable adults. And vulnerable adults are adults, no matter what the age, 18 through the entirety of their life, where there may be somebody who is struggling with providing services to themselves with self-neglect, or maybe they're vulnerable to exploitation, whether that's financial exploitation or other. That's the work that we do around adults. They're vulnerable, there's some need that has been expressed to us or they have expressed that says that they may need some help. So the confidentiality statutes for them is also included in this legislation. And then page 6, lines 13 through 22 are for what is called welfare. And those are our benefit programs. That gives us the permission to share internally with our SNAP program, our TANF program, weatherization, child care assistance, and utility assistance. And then the effective dates and a reporting mechanism that says on October 1st, we will submit to you any information of what we've done since the passage of the legislation, give you an update and anything that we're finding as a result, plus whatever else you may want to know. And that's the bill, Mr. Chairman.
Thank you, Director. Chairman, any other testimony? Committee, any questions so far? All right, who else in the room would like to testify with regards to House Bill 48? Anyone else in the room wish to testify? Seeing anyone on Zoom? All right, I'm gonna close public comment. Committee, what's your pleasure?
Move the bill. Second.
Okay, we have a motion to move the bill do pass from Representative Shestick, seconded by Representative Filer. Amendments, proposed amendments, anyone? Okay. So let me put a couple of comments. I think Representative Shesta can speak to this as well, that one of the challenges that we've had over the years on Judiciary Committee is data. Trying to make good policy decisions when you lack data. And so the director referenced being able to connect what programs do we provide within the Department of Family Services that maybe has an advantageous impact on people going on and becoming engaged in the Department of Corrections? Can't answer that question right now, right? The data doesn't allow us to connect. We can also end up with, families receiving services from education, from family services, from Department of Health. They may have 3 different case managers and all the rest, right? And so the sufficiency of being able to communicate with one another while respecting confidentiality is what this bill's all about. So we have a motion on the floor to pass. Anybody else wish to make a statement on the bill before we vote? Representative Bratton?
Thank you, Mr. Chairman. I just, before we voted, I just wanted to say I appreciate, your coming forward and with this bill and to look back and at the, what happened during the interim committee. But I just have some great concerns with the, how broad the scope is with this bill and what you tried, how you tried to put it all into the bill that you did. Just there's, as far as, who can have access to this research. And just, I have a lot of privacy concerns, so I just wanted to let you know. Thank you.
Anyone else? Representative Webb?
Thank you, thank you, Mr. Chairman. My only question really is what happens to this data? How long is it retained? And what is the
Director?
livelihood of it?
Mr. Chairman, Representative Webb, it depends on the data. We have a statutory requirement for our protective services data, our social services data, for I believe it's 50 years. And that's just because of all sorts of reasons. I mean, it's reporting, it's knowing and recognizing a family, but that's the requirement. The data that we would be collecting for the purposes of the research would come together and we would connect it and then we would make it de-identified. So once that information is connected, we would remove the identifying information, names, things that could help others kind of piece together who we're talking about. And then that information in aggregate is what gets analyzed. So we're asking for sharing of the data in that purpose for reasons to connect, to say this person and this person are the same person. Once we make that connection, then we remove any of the identifying data. So with that data may exist for a while, but it doesn't exist in a way you could identify who's who, if that helps.
Representative, got it, all right. Representative Brady?
Thank you, Mr. Chairman. I do have a question or statement where it says the director shall, so mandatory on page 2, to collect this data. So I'm concerned about the individuals whom this data is going to be collected. Is there going to, I think they should have an opt-out option. I suppose that can be directed later, but also them be able to get their information prior to participating to be able to approve or deny whether they want to move forward. I'm just concerned with shall.
Is that a
Thank you.
question or
Oh, just a statement.
any further? Seeing none? No motions for amendments? No further discussion? Call the roll on 48, please.
Representative Brady?
I think, I say no. This is too much, too broad. No.
Representative Bratton,
No.
Representative Chesnick,
Aye.
Representative Feiler,
Aye.
Representative Kelly,
No.
Representative Lean,
She left a vote of no.
Representative Singh,
Aye.
Representative Webb,
No.
Chairman Washit.
Aye.
We have 4 ayes, 5 noes.
And with that, House Bill 48 did not get a motion to pass. That takes us to House Bill 49.
Thank you, Mr. Chairman, and I'll ask our our Supreme Court Chief Administrator, Alyssa Butler, to join me in helping the explanation. So, Mr. Chairman, this is this bill is the result of two things. One is we are trying through the mental health task force, in the Supreme Court, we've implemented a diversion court system that you heard the Chief Justice explain to the legislature the other day, in trying to divert people away from the court system and get the mental health resources they need in lieu of going to jail. And the existing treatment court statutes, which prior to 2023 were housed in the Department of Health. When we moved them over to the Supreme Court, and as they went through them, they identified changes that needed to take place and upgrading of language. And this bill reflects on that issue. So it covers the diversion pilot program and the treatment court statutes. In this bill, we'll amend the language on the treatment court statutes in Title V. And so if you have your bill, starting at the bottom of page 2 and going to the top of page 11. Title V is the treatment court statutes. Then we also go into the public defender statutes in Title VII, and we make that change in the middle of page 11. One of the things that you see in this bill is changing the term that we use as substance abuse to substance use disorder. This is a change that we've been making in our statutes over the last few years to better align with the terms used by mental health professionals. Changing the term does not change the number of people we are describing, the assessments used, or the type of treatment that we use. It's interchangeable. If you look at your bill, starting at the bottom of page 11 and going to page 22, we go into the Addicted Offender Accountability Act in Title VII, the Child Protective Services Act, and Child in Need of Supervision Act in Title 14, and Operation of Motor Vehicle Act in Title 31, and the Food and Controlled Substance Statutes in Title 35, and do one thing, which is to change the term of substance abuse to substance use disorder. So that second half is just changing terminology. We put substance use disorder, and it refers to 35-1-613, which is in the Department of Health statutes, which means the use without compelling medical reason of any substance which results in psychological or physiological dependency as a function of continued use in such a manner as to induce mental, emotional, physical impairment or to cause socially dysfunctional behavior. As we visited with mental health professionals, they said, it's easy to understand if you're talking about substance abuse versus substance use, what is abuse? And so when you talk about prescription drugs, you can say, well, you're taking them outside the prescription and you're abusing that. But if you're using illegal drugs, what is abuse? What's the right dosage of heroin? What's the right dosage of cocaine? And so it just didn't conform. And so the substance use disorder with this definition better captures all uses of those type of substances. And so that's why you see that, and that's kind of the reason behind that. These existing programs are funded through the Supreme Court's budget. The diversion court pilot programs that we currently have are not in the budget. They're currently funded because they're just pilots. They're not a great expense. And they've been able to fund those out of their current budget. Once we get a better feel through the pilot programs, the true associated costs with that diversion court, there'll probably be an additional ask at some time in the future. The treatment courts apply for these fundings, so we, the legislature, appropriate funds to the Supreme Court for treatment courts, and then the treatment courts around the state apply for a grant. And Ms. Butler's office reviews those and provides those grants out. Are we able to meet all of the funding needs? You could look at any one treatment court in 1 year, it may be yes, and they can carry that over, and the next year it may be no, depending on the number of people that come into the treatment court or referred to them. And the capacity for the treatment courts to accept additional individuals would vary from program to program. But it's also important to recognize that treatment courts aren't a residential setting. We don't send them there to stay. So if your Representative Kelly was referred to a treatment court, he would probably drive himself there or to treatment, and he would drive himself back and forth or have a family member or a friend take him there. It's not a residential thing. So there's some, as we went through this, there's some concern that, well, if there's an issue that one county does not have a treatment court, could they then drop some indigent people off in another district? They can't, because they have to be referred to the treatment court. So you can't take an indigent person living in your community and drop him off and expect that he's going to get treatment court services. However, let's talk about indigent individuals. If Lloyd was an indigent individual and he has maybe a dual diagnosis, I have a mental illness and a substance use disorder, and my local police pick me up, but I'm living under the 2nd Street Bridge, they refer me to a treatment court or something for what I'm doing. Who pays for that? When we done the behavioral health redesign, in our state's budget to the Department of Health, we have one of those is for mental health resources. And when we redesigned that, we identified priority populations. And we says, for the state's general fund dollars to receive mental health services, it's these priority populations. And we've established those. It's the people that are indigent with mental health. They're people coming out of our judicial system, out of our prisons, our state hospitals. Those people with persistent mental illnesses, those are priority populations. So in this situation, the indigent person's assessment or treatment would be covered through the Department of Health, back to the community mental health provider that is providing that. So the intent of this bill, Mr. Chairman, is to update the statutes and conform the treatment court statutes and complete the diversion court statutes to fill the gaps that have been identified. When we first started with the treatment court and we identified the statutes, as we got the pilot program in Gillette, we identified a couple of other things that in order for them to function fully, we needed to add additional statutes in. That's why we have the effective immediate requirement, is because we're trying to make sure that we're providing the services in the pilot programs to comply with statute. Kind of something good for us to do. So as we go, Ms. Butler will explain some of the stuff in the bill, but I think for the intents and with time, Mr. Chairman, we break out that 11 through 22 really is just changing that term from substance abuse to substance use disorder, synonymous with what we're intending to do. So the real construct of amended language comes in Title V and in the Public Defenders Act, and I'd ask Ms. Butler if she could explain that a little bit.
Ms. Butler, anything to add?
Mr. Chairman, I'm happy to walk through some of the questions in the bill. I don't know, Mr. Chairman, because we have such a new committee, and my apologies. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. I will be speaking to you a lot over this session and during the interim, so I look forward to working with you. Mr. Chairman, I don't know if it would be helpful for me to explain treatment courts and the diversion program and kind of the distinction between the two, just so we have a kind of a better grasp about how those two programs work.
I think that would be beneficial.
Okay.
Briefly.
Yes, Mr. Chairman, I will be brief. So treatment court programs have been operational in Wyoming for many, many years. They're incredibly effective based on the data that we receive both in our state and then nationwide. So what happens in treatment courts is they are post-adjudication, which means that the defendant has gone through the court system and they have been convicted of a crime. And those crimes, in order to qualify for treatment court, those crimes have to have a substance use component. So there is some substance use component that has impacted that person as they are committing these crimes. A lot of times it's a DUI, and most of them are felonies. We do have a few misdemeanor treatment courts in Wyoming, but the vast majority of treatment courts in Wyoming are felony treatment courts. And so what happens is the defendant is convicted, and the judge essentially has in their toolkit this program that allows them to send the defendant to treatment court rather than sending that person to jail or to prison. And so it's a way for them to get treatment for their substance use disorder rather than sending them to jail. There is a component there where if the defendant fails out of treatment court, so if they don't succeed in the treatment court program, they can be sentenced to jail based on their conviction. And so if the defendant goes through treatment court, and when you think about treatment court, what happens there is the defendant has a case manager, they have to check in regularly, similar to probation, and meet certain criteria, and then they meet with the treatment court team every so often, and that includes the case manager, probation officer, other treatment court team members, the judge, and walk through how they're doing, if they're succeeding. So if that defendant carries out that program and is successful, they graduate from treatment court, and that's the end of that crime, right? And so, as I said, they've been incredibly effective. Those who are not successful in treatment court, as I said, go back to court, regular criminal court, and they can be sentenced on the underlying crime at that point. Diversion court is a little bit different. And so the purpose of diversion court really is to identify those folks who commit low-level crimes, misdemeanor crimes, who are suffering from some form of mental illness. And so I don't know if you all see this in your communities, but we do see them in communities across the state where we have folks who do suffer from mental illness, who may not have a home, who may be homeless, who are getting picked up on very low-level charges, trespassing or some misdemeanor charge, and they go to jail for a couple of days. They don't get treated for their mental illness. They go back out on the streets, and we see them again in a couple of days. And so this really is an attempt to really halt that cycle where those people suffering from mental illness are cycling in and out of jails. And so diversion, what happens there is a defendant will come in and will be identified as somebody who may be suffering from mental illness. They will go through a screening process to determine if they actually do suffer from that mental illness. And if so, they can be diverted to diversion court. And through diversion court, we will have providers through behavioral health redesign who will provide treatment services to those folks who are suffering from those mental illnesses, provide them with medication, very personal care plan for that individual. And they will, again, similar to how a treatment court works, they'll meet with the judge every so often to check in, see how they're doing, keep them accountable. And if they're successful in that treatment court program, they're never actually convicted of that crime. So this is all pre-adjudication. And so instead of being convicted for these low-level crimes, they are diverted to treatment, and the Their charges are generally held in abeyance, and if they're successful in diversion court, then the charge is dismissed and they continue treatment with the provider. So that's really those two tracks, Mr. Chairman. And as Chairman Larson explained, the intent of the bill here today is to do a couple of things. And the first is to fill some holes in the treatment court statutes for treatment courts themselves. There are a few things that, as we talked to coordinators throughout the state, they requested some changes to those treatment court statutes. The second thing is to expand the ability of treatment courts to participate in diversion as well as treatment courts. So do both pre-adjudication and post-adjudication. And so that's the second step. And then the third, as Chairman Larson said, is just to conform some language to what is used basically in the medical industry and counseling services to substance use disorder rather than substance abuse. And so that's just generally accepted. And so, Mr. Chairman, that's a quick explanation. I think if you would like to step through the bill, Ms. Johnson can probably do it much more briefly than I could. So that would be my suggestion, but I'd be happy to answer any questions.
Okay. Ms. Johnson?
Thank you, Mr. Chairman. I can walk through this really quickly if you'd like me to. So beginning on page 2, several treatment court definitions are amended. The definition of applicant was changed to include one or more governing bodies. The definition of continuum of care was amended to include mental health treatment. Dual diagnosis was amended to say substance use instead of substance abuse. Participant was changed to include persons with mental illness or dual diagnosis who have committed an offense, including those who have had law enforcement contact with or without arrest. Program was amended to include one or more local court supervised treatment or mental health programs. Referring judge was amended to strike substance offenders and include participants. Substance abuse assessment was changed to substance use disorder assessment. Substance abuse treatment was changed to substance use disorder treatment. Substance offender was changed to include a person arrested for, charged with, or adjudicated for a substance-related offense. And then the definitions of mental health treatment, mental illness, and substance use disorder were added to the bill. And then if you turn the page, Wyoming Statute 512-105 was amended to include unmet mental health needs and mental health screenings. Then under subsection B there, the goals of the programs were amended to include striving for recovery and mental wellness of participants, and to reduce the number of people with mental illness in jail, criminal court proceedings, and the state hospital. Wyoming Statute 512-106 was amended to change referring judge to referring judges. Wyoming Statute 512-109 was amended to remove substance offender and insert participant. Subsection C indicates that referral and participation in a program and consent to participate shall be governed by the rules adopted by the Supreme Court and under Title 14 for juvenile participants. Language regarding consent is stricken from subsection D, and a new subsection E indicates that a program may accept participants from any other jurisdiction in the state. 512-110B indicates that if a participant is participating post-adjudication, they may be subject to incarceration as a sanction. A conforming amendment was made to 512-111, and then 512-115A was amended to strike substance abuse and insert substance use, and to show that participants may have to submit mental health history to the program team. All participants may have to disclose the number of children they have, as well as their mental health records. And then there was a change made to the public defender statutes under 76104E. That subsection was created to show that the public defender is authorized to serve on a court-supervised treatment program team and may represent participants in those programs, including sanction and expulsion proceedings. And then, like Chairman Larson and Ms. Butler said, all of the amendments between page 11 and the bottom of page 22 are just conforming amendments. Section 2, way over on page 23, or actually I think that's still on page 22, indicates that Wyoming Statute 512-107C2 and 512-109A and B little I and B I and V are repealed. And then section 3 is a rulemaking section. It also indicates that the Supreme Court may make any necessary request to support court supervised treatment programs in its biennial budget request. And then section 4 is an effective date. And I would be happy to take any questions.
Thank you. Committee, any questions for any of these witnesses?
Yep, Mr. Chairman.
Representative Kelly?
Thank you, Mr. Chairman. I wanted to confirm, if I heard this correctly, that people can take advantage of this program even if they have not been previously diagnosed with a mental illness.
Ms. Butler?
Mr. Chairman, Representative Kelly, that would be correct. There's not a requirement that there's a previous diagnosis, but what will happen in diversion court is when they come in and they are identified as somebody who could benefit from diversion court, they will go through a screening process. So they'll go through a quick screening process. Usually that will happen if they're in the jail, and then a much more extensive screening process with a behavioral health provider to ensure that they actually have a diagnosis of a mental illness under the rules to qualify for the program.
Mr. Chairman.
I
And
heard her voice.
you did.
Mr. Chairman.
It wasn't God. So, Representative Kelly, also bearing in mind that we use that dual diagnosis, so it could be a mental illness or a substance use disorder, so they could come in without any suspicion of a mental illness, but having a substance use disorder, but then that assessment would still take place.
Representative Filer?
Mr. Chairman, thank you. I got a question. With the diversion court system, right? So is this just another tool that the judges can use to maybe, one, not overflow our jails, especially for some like mental health or some of that nature? But I think my question would be really is when I was campaigning, there was a lot of concern about the mental health and jails being overflowing with, folks that are homeless and things like that. What can we do as a community to be able to provide them some other avenue besides putting them in jail? But the one question was always, asked too is, how do we fund something like that? So if somebody goes through that, does the courts pay for that, or does that have to come from the Department of Health when they do their assessment? And they say that there is a mental disorder or something like that. I just hate to see two different budgets being used for the same thing, when we were talking about the previous bill, trying to streamline some things. But if you could answer that, that'd be great.
So, Mr. Chairman, Representative Filer, so there's kind of two jurisdictions there that come. So if the diversion comes through the diversion court, which is in the Supreme Court, and then they agree to that, they would then go to a community mental health provider, which is under the jurisdiction of the Department of Health. The Department of Health and the Supreme Court have worked very closely in establishing the line in the sand and who's responsible for what. But paying for that largely is, as I referred to earlier on this priority population. If they come and they don't have the means, then as priority population, that can be their funds to cover that, okay, because they are a priority population. The intent of the diversion court is what good are we doing putting people that have a mental illness or substance use disorder in jail? They sit and languish, receive no services, and only exacerbate the problem. Whereas if we could divert them to get the correction that they need, it's a win-win for everybody.
Ms. Butler, are we, with the diversion courts, they're still in a pilot phase, right? Can you explain where we have them? They're not statewide, right?
Mr. Chairman, that is correct. Diversion court still is in pilot. The only operational diversion court we have right now is in Campbell County. That was our first pilot that was started about a year ago. We are working with both Laramie County and Natrona County right now to implement diversion courts in both of those counties. So it's a work in progress to expand.
Representative Filer, a follow-up?
Yeah, thank you, Mr. Chairman. I would I was kind of wondering, I don't know all the new lobbyists or anything like that, but is the Sheriff's Association mentioned anything about this, as far as the cost savings to their county jails and stuff like that?
I see Mr. Thompson in the back room. We'll have him up here in a moment. If you want to respond, Ms. Butler, or?
Mr. Chairman, I was just going to say, in our conversation with sheriffs in those counties where we've looked to expand it, they're incredibly supportive simply because of the reason that you've identified, which is a lot of those people are languishing in the jails. And unfortunately, that means the sheriff's offices are responsible for providing mental health support, which is not necessarily in their wheelhouse.
Okay. Representative Bratton.
Thank you, Mr. Chairman. So I have some questions about the pilot program in Campbell County and would like you to elaborate on the details of that and the percentage of, participant success. I've done a little research into that, but I would like to hear what you have to say about that.
Ms. Butler.
Mr. Chairman, Representative Bratton, so in Campbell County, operating for about a year now, we have had one successful participant, so one graduate from that program. I believe they have identified 12 people in the course of a year who could potentially qualify for that program. They admitted, I believe, 4, and the ones who were not successful, there were a couple of different things, and I don't know that they would call them unsuccessful, but one of them, their mental health needs were too acute for something like a diversion program. And so that person, that individual went on to receive services through a different means rather than diversion court. But what we have seen is the one successful participant was one that had cycled through the criminal justice system and through the jails many, many, many times. And so since that time, since the successful participant graduated, they have had no jail time. That graduation, I believe, was in August of '24. So we're looking at, with quite a few months where that person has not been seen in the jail system since. So it's still in its infancy. So we don't have a lot of data yet, but we are seeing some successes.
Representative Larson.
And it's maybe important to note also that the model that we used to form the pilot programs is modeled after the Miami model, which in Florida, a number of us went back there to learn. It's become quite acclaimed on working, and we went, researched that, spent some time with those folks there to understand how they implemented it. And one of the things that they pointed out is each locality is a little bit different, and it takes some time. You've got some fundamental things, but it takes some time to get it into place and get it working to where you have the buy-in of the community and all the stakeholders. That's why we should have just implemented it. We're using some pilot programs to figure out what we don't know.
Follow up?
Thank you, Mr. Chairman. So the pilot project in Kimball County was for severe mental illness. And as I was researching it, schizophrenic, schizoaffective, major depressive, PTSD, bipolar. As I listened back to in all the committee hearings, there were 12 referred, 6 screened, 2 were accepted, 1 was a non-compliant discharge, and then the 1 that is expected to graduate. So, so 1 potential success rate. So it seems like it was a high risk, high needs, high maintenance program. Is that correct?
Mr. Chairman, Representative Bratton, that is correct.
Mr. Chairman. Follow up. Thank you, Mr. Chairman. So this House Bill 49, this is adding mental health treatment for individuals with mental illness to the treatment courts. So it's a different, it's a different population now that we're applying this to, based on a study that was done with a pretty small group, different, kind of a whole different deal. And mental health treatment, as you defined it, medication, therapy, prescribed care designed to address disturbances in behavior, emotion, thoughts, or judgment, that is a very broad category and very different from the severe mental illness defined by statute as condition which is manifested by a disorder or disturbance. Anyway, it expands it, and so I'm just a little confused as to what the pilot program has to do with this bill, because they're really looking at two very different populations. Can you help me out there?
Mr. Chairman, Representative Bratton, so what this bill does, it allows the treatment courts, so within each treatment court, there is a treatment court team, there is a treatment court coordinator, right? So they have a whole team that is devoted to treatment courts. So what this bill does is it allows that treatment court team to expand to include diversion court. And so agreed, they are two very different populations. It's two different models. Treatment court is a lot more peer-based. So you have a lot of sessions where all of the folks who are participants in treatment court participate in one court hearing. In diversion court, it is much more high need, so more one-on-one. So it is a high need kind of program, and serving two different populations, but it does allow that treatment court. It doesn't require it, but it does allow the treatment court to expand to provide those services and to do both diversion court and treatment court with the same staff. Ideally, if we had enough people and enough money, we would have two different teams, right? We would have a diversion court team that would deal with diversion court, and you would have a treatment court team that could deal with those other kinds of offenders. There's a lot of reasons in Wyoming why that's not happening now. One is because it's a pilot program. We don't have an extra staff in each county to be able to have an entire diversion court. We don't have the funding to do that currently. And so with the pilot program, the thought was, let's see how this can work when we expand a treatment court to include diversion. And it is a lift for that treatment court, there is no doubt. They have borne it well in Campbell County, and other counties are interested in doing that. Again, it's not a requirement of the treatment court. It's something that's available to them, and that's what this statute does, is it allows that treatment court to expand if they so choose.
Okay, we're coming up on 9:15. Further questions for these witnesses, and get the others in the room? Representative Bratton.
Thank you, Mr. Chairman. So I also have a question. I wanted to ask you about the cost of adding the mental health treatment to the treatment courts. Yeah, could you speak to that?
Fiscal note?
Mr. Chairman, Representative Bratton, I believe that would be a fiscal note, but what's happening right now is, as Chairman Larson explained, it's all through the behavioral health redesign. So the mental health treatment is being done by behavioral health providers who have contracted with the Department of Health. And so the folks who are getting that in-depth personal one-on-one care for mental health are using the behavioral health centers in the state to do that. So the cost right now on that side for the treatment itself is borne by the Department of Health and the behavioral health providers.
Follow-up.
Thank you, Mr. Chairman. So, so as I look at these numbers and the substance abuse, so the people who are currently being treated for substance abuse, and I'm getting the numbers from the your task force. So for substance use disorder, currently people who have the substance use disorder is like 25 million in the United States, and it's a lot, and that's what's being treated. And then we're going to add mental illness is 150% larger than that. So that is, if you add that onto it, it is going to substantially increase the costs to the Department of Health. Even though the fiscal note they said was, not to be determined, or it couldn't be determined at this time, but just the sheer numbers that come from the SAM HSA show that a lot of people have, not only have mental health or mental illness along with the substance abuse. Probably 50% of people approximately who have substance abuse disorder also have mental illness. And then another, more than double that, just have mental illness. And all that would have to be treated. It's like over an 80% increase in the people that would qualify for this. Can you speak to that?
Mr. Chairman,
Representative Larson.
Representative
Just so
Bratton,
we're clear, this statute doesn't compel, right? Just simply authorizes, right? You want to explain all that?
it does. I think I would respond, Mr. Chairman, Representative Bratton, just to the sheer concern or impacts that mental health and substance use is now being identified, right, in our society. Hence, that's really why this legislature took on that behavioral health redesign, because previously in our community mental health system, which was created federally in the 80s and was at the county level, and then they raised their own money, and in Wyoming that evolved into a state program where a community mental health provider could apply for a contract with the Department of Health. Then services was provided kind of as an open door policy. Who comes in the door for depression, anxiety, what, depending on the acuity of the mental illness or the substance use disorder. And they would be reimbursed based on a model showing an hourly rate for counseling or professional services. What this legislature, while my time in here, had often felt is that for the general fund dollars that we spend on mental health, we've seen the populations that really needed mental health services perhaps not getting them as readily as they needed to. So we reached out to the community mental health providers and said, if we were to create a system, who are the populations that we would fund? Who should get those funds? And those became the priority populations. And so as we've seen and as we sense and as we've anticipated, the increased number of people requiring mental health services, what's the state role? What's the state's role in providing those, right? And so we've come back and said, for the state dollars, these general fund dollars, we want these populations served. Now, you can continue to accept anybody that walks through your door, get cash, bill their insurance, bill Medicaid, bill whomever. But to get the state general fund dollars, we want these acute, high priority to keep families in place, to keep people out of the emergency room, to keep people in their homes, keep them identified. Those are who we would reimburse you for with state general fund dollars, because the increase in mental health and substance use disorder is accelerating faster than the resources that we have available to cover everyone. And is it the state's job to provide mental health services to the population as a whole? And we've said, no, it's a priority population.
Okay. We're 20 after 9. I know there's probably some other people in the room that wish to testify. We'll have an opportunity for some further discussion in a little bit. Let's get the other witnesses up. I want to make sure we have plenty of time for public comment. Who else in the room would like to testify on this bill? Ms. Somerville, Mr. Thompson? Good morning. Please identify yourself for the committee and the record, and tell us what you want us to know about this bill.
Thank you, Mr. Chairman, members of the committee. My name is Andy Somerville, and I'm the Executive Director for WAMSAC, which is better known as the Wyoming Association of Mental Health and Substance Abuse Centers. For those of you that I haven't had the opportunity to meet, just in general, we are the mental health providers. So we tend to collect and work on a lot of issues around mental health and substance abuse. We're community mental health centers, PRTFs, some other types of providers in the communities. Mr. Chairman, this morning my comments are in support of this bill right now as it's written. So the community mental health centers are providing the services in the diversion program in Campbell County. They are providing services in a municipal diversion program that's up and running in Natrona County. There's not a state level program yet. But we are the provider. And what I want to share with the committee is that what we know in mental health is that you have to meet somebody where they're at to get them the services. And there are multiple doors for somebody to walk through. You can give somebody a referral over and over and over again. They don't have to take it, and they don't have to come in for services. But what we hear from our community stakeholders, our county sheriffs, our chiefs of police, other social service providers from our state partners at the state hospital that are seeing these folks over and over and over again, is we've got to find a way to get to these people a little bit better. We've got to find a different avenue to make an impact. And so we know that treatment courts in general are very successful. They work very well for the participants that put in the time. They've got pretty good graduation rates. We think that's an excellent return on investment. The idea of stopping that cycle where they're going in and out of the jails, costing the county's money, costing the state money, being away from their families and out of their communities, all of those things are things that we want to avoid. On the mental health side with this bill, what we're opening the door on is for the state to take advantage of something that colloquially is called the black robe effect. We know for some mental health patients, one of the most effective tools that's out there is to have them sit with a judge. They can sit with a provider, they can sit with a counselor, they can talk to law enforcement, they can talk to all these people. But sometimes when we have somebody that's seriously mentally ill, having them have a touch point with a judge is incredibly effective. They just check in on them. It helps keep them med compliant. It helps just keep them in a better space. And what we're trying to do with these folks is keep them in their communities, keep them with their families, and keep them out of the jails. We know a lot of times that the first contact with somebody that has developed a serious mental illness is often with law enforcement. And that's obviously not where we want to go. And that is certainly what we hear from our law enforcement partners across the state. So, Mr. Chairman, I know we're short on time, but I just want to say from the provider standpoint, we do think that these diversion courts and certainly the treatment courts are things that we should have operational in Wyoming. We think that they save the state money. I just remind this committee that the state hospital costs more than $1,000 a day for somebody to be there. And the earlier we can get to somebody, the better chances we have of improving their outcome and keeping their in the communities. There's a lot of costs when people end up in state involved and county involved institutions. And just on the humanities side, if we can keep them with their families, we can keep them employed, that's what we're going for. So, Mr. Chairman, I would stop there for time and brevity and stand for questions.
Thank you. Representative Lean.
Mr. Chairman, thank you for coming today. I just have a question about the case workload. We know that medical providers across the state are at their max capacity or sometimes in a shortage of. Does expanding this treatment court overload your casework?
Ms. Somerville.
Mr. Chairman, Representative Lee, that's an excellent question. You've heard a little bit of information about behavioral health redesign this morning. That is provided by the 8 community mental health centers that cover all 23 counties. Currently, drug treatment court is funded separately. They have separate grant dollars for that. As that expands, I think that is something that we're going to have to look at in the future. But this bill does not expand the number of slots or expenditures in that program. Adding the diversion component for the mental health clients, right now we're kind of, as the community mental health providers, wrapping our arms around that under behavioral health redesign. As we get down the road in 5 years, we might have to have a conversation about what that looks like. Right now, with the 2 pilot programs that we have, we can operate within that existing budget under those priority population slots that's provided under that behavioral health redesign program. And I think it's something that we're going to have to keep an eye on as we go forward, but I'm not concerned here or in the next few years about what that looks like yet.
Thank you very much, Ms. Somerville. Appreciate you coming
Mr. Chairman.
today. Ms. Thompson. Welcome.
Mr. Chairman, my name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. Our membership includes administrators from all law enforcement agencies in Wyoming, from state to local, and I'm here to represent their voice. I hadn't anticipated testifying on this topic, but there were some questions that were raised on it, so I might not be totally prepared to answer those questions. But based on the conversation that we've already had this morning, Mr. Chairman, I wanted to add that as we look at the pilot program in Campbell County with 12 possible people involved and maybe 1 or 2 graduates in the timeframe that it's been up and running, understand that that's a pilot program. So it's going to take some time to get that going, and the lessons learned there will help inform the other counties that are interested in pursuing that. The question was, what are we hoping to save in bed space or whatever it may be on the county level and the jail level? And there's a couple of things there. I don't know that if you look at bed days and food costs specifically, what that number will be, because that's easy to track, and we can look back and say that if this person is in treatment and then makes it out into the community and is living successfully, they're not in the jail awaiting court, there's a savings there. But I think what's most important for our sheriffs and their staff is the reduction in the impact on that mentally ill person in the jail. They're very time consuming. They take a lot of staff one-on-one attention. So the savings is something that we might not be able to capture, but things like morale and retention of employees, the long-term operations of the jail and things like that. So there's a lot of components to that if we can successfully get people with mental illness into the right program that often isn't a jail, then that is our ultimate goal, and law enforcement can be focusing on the criminals. I also wanted to quickly mention that my understanding of this pilot program is it is for those low-level misdemeanors, not violent criminals. There's a definite crossover with our violent crimes and mental illness that we're still going to have to be dealing with in the facilities. So then there was another question about, I think that answered it, but Mr. Chairman, I'd be happy to answer any specific questions.
Thank you, Ms. Thompson. Questions? Representative Bratton.
Thank you, Mr. Chairman. Thank you for coming, Mr. Thompson. Has there been any discussion about the resources, about those resources that are being saved, being reallocated to the treatment courts from your department? Like, have you heard anything about that? I didn't hear anything in the testimony or in any of the committee hearings that I listened to.
Yeah, Mr. Chairman, I'm not clear on the question on what resources you're talking about. Staff resources that aren't dealing with that issue, then what can they be reallocated for?
Representative Bratton,
Mr.
clarify.
Chairman. Yeah, just money, you had said that there money saved, although you said perhaps there wouldn't be any actual.
Right. Yeah, Mr. Chairman, so if we look at the cost of operating a jail, say the jail has 100 beds and it has 20 employees, there's a fixed cost. The light bill's the same, the payroll's the same, all those things are the same. So whether there's 75 people in the jail or 100 people in the jail, the cost is still the same. It's the per bed cost that we often look at, but it isn't necessarily an indication of how we're going to save money. You have to anticipate for providing this service for what your capabilities are. Some days you have 50 people in there, some days you have 75. But the long-term impact is what I'm talking about with retention of employees. If an employee is constantly dealing with mental health issues in a jail, they didn't come into law enforcement to be a social worker, they came in to work in law enforcement. So the long-term impact on that mental health cases with the employee tends to affect a morale and retention of employees. So cost of training someone, keeping them on staff long-term. There's just so many components of this that I don't have the answers with the bed date stuff, but there's just so much more to this that our ultimate goal is hoping to get mental health people into the programs that best help them and don't clog the criminal justice system.
Very good. Thank you. So we're at 9:30. Is there anyone else in the room wishing to testify on this bill? Please come forward. Please identify yourself for the record and tell us what you'd like us to know, and we are kind of up against the clock.
There we go. Mr. Chairman, members of the committee, my name is Clark Fairbanks. I'm the Director of Wyoming Youth Service Association, and I come before you just in support of this bill. Little background briefly, I was Director of Youth Emergency Services for 25 years in Gillette, was a founding team member on the drug court team in Gillette, so I can speak to the effectiveness of drug courts and again, the impact that it has on children and families. We know substance abuse and mental health, unfortunately, are affecting children, families, and our community. And when I say community, that includes our workforce. Oftentimes, from my experience in treatment, dual diagnosis, there's a high frequency of people who suffer from substance use disorder, who may have an underlying mental health disorder. Which came first, chicken or the egg? Doesn't really matter. So I'm personally just excited to see a pilot program that also addresses from a preventative standpoint to address mental health needs of people who get involved in the criminal justice system, to get the mental health services that they need to stay in their community, in employment, with their family, to be healthier. Makes our community, makes our state healthier. So that would just be my comment. I would stand for any questions that you or members have.
Question? Thank you for coming in and offering testimony this morning. Thank you. Anyone else in the room wishing to speak on House Bill 49? Anyone on Zoom? So I'm going to close public comment. Committee, what is your preference? Weiler?
Mr. Chairman, I move the bill.
Move the bill for due pass. Is there a second? Second. Second by Representative Shustic. Amendments, any proposed amendments? Seeing none. Discussion on the bill. Representative Kelly.
Thank you, Mr. Chairman. I'm glad you started today by saying we were going to be talking about tough issues. This is one of those that, having experience as an educator of people working with these types of issues, having befriended people who've struggled with this, and being from a community where we lost one of our law enforcement officers to an individual who struggled with this, I understand the dire need to do something about making sure that people who are sick get help, not punishment. I've got severe reservations here about the idea of people being able to enter these courts without a diagnosis ahead of time. So while this could serve to help people who really need it, I fear the unintended consequence of people manipulating the system. Substance use disorders are easily testable. People test positive for substances, or they don't. We diagnose many mental illnesses based on behaviors, questionnaires, and the judgment of an individual. I have concerns about people manipulating the system by simply doing an internet search of the right things to say to a medical healthcare provider to get a diagnosis, considering the number of people already incarcerated who could be diagnosed with antisocial personality disorder, oppositional defiant disorder, severe depression, bipolar disorder. I have a concern greatly about the system being manipulated for people looking to avoid convictions through what they found a newfound loophole. Thank you.
Further discussion on the bill? Representative Filer?
Thank you, Mr. Chairman. I'll be really brief. I'm going to be in support of this bill for the simple fact that I think this is something that's needed in all of our communities and at least gets that conversation started. Understanding that of Representative Kelly's concerns, I think those are major concerns too in our communities of how we go and proceed with this. But I think us moving this bill forward will give us those chances to maybe make amendments, talk to some more folks, and maybe make this bill even better when it gets out to the floor for the whole body. So that's the reason I'm in support of this.
Further comments? Representative Shustic.
Thank you, Mr. Chairman. I'm also in support of the bill. Number of reasons. Number one, it's the right thing to do for these individuals. The criminal justice system is not equipped the prisons are not a good place to provide mental health services. And keeping people out of jail will save us money, I believe. And therefore, I'm very much in support of this bill.
Okay. My comments on the bill, I just want to remind the committee that this is like a foundation bill. This is not a bill to expand programs. There's no appropriation in here to grow these things. It's simply giving the grant providers and the programs the opportunity to make these adjustments and use the vocabulary that is now standardized in the diagnostic and statistical world of mental health. And so we're switching from the, term that most of us grew up with and to a different term in terms of drug use or substance use disorder. So for all those reasons, I'm going to support the bill. It doesn't have an appropriation. It doesn't really grow anything. It's simply laying a foundation that we need as we continue this evolution towards meeting the needs of the mental health people. I've talked with so many people that work in jails, and these, I just want to echo what Mr. Thompson said about the wear and tear on people who are not trained to deal with mental health. They're trained to deal with the jail population, and you get people with severe mental illness in a jail. It's a different population, and it's really difficult for those employees working in that jail on a day-to-day basis to deal with some of these individuals ongoing. And so if we find ways to divert those folks out of the jail system, I think it's be advantageous to us. So with that, Mr. Cheshire, call the roll, please.
Representative Brady?
No.
Representative Bratton?
No.
Representative Chestek?
Aye.
Representative Filer?
Aye.
Representative Kelly?
No.
Representative Lean?
No.
Representative Singh?
Representative Singh left a vote of aye.
Representative Webb?
No.
Chairman Washut?
Aye.
4 ayes, 5 noes.
With that, the bill does not receive a due pass recommendation from the committee. So thank you all for coming here. We're cutting our teeth on the first bills of the session. We'll be back at it on Friday morning. Thank you all for your efforts today.